Elizabeth Holmes went to prison for selling investors a blood testing future that did not exist. Yet the same jury did not convict her of defrauding the patients who actually received Theranos test results. That is difficult to square with hidden demonstrations, unauthorized drug company logos, and a proprietary machine that ran only 12 kinds of tests. So, how did one collapsing laboratory produce both guilt and acquittal? Theranos had once reached a private valuation of roughly $9 billion by promising fast, accurate testing from a finger prick. The promise was not merely that the technology might work someday. Investors were told, in substance, that it already worked, had been validated, and was transforming medicine. I am Archivist Kane, and this file turns on the distance between a difficult ambition and a knowingly false present tense fact. Federal prosecutors divided that distance into two alleged schemes. One accused Holmes and Theranos, President Ramesh Balwani, of deceiving investors into sending hundreds of millions of dollars. The other accused them of deceiving paying patients through advertisements and test services. Both theories use wire fraud, a crime requiring a knowing, material deception intended to obtain money through interstate communications. A failed invention was not enough. Bad management was not enough. Even reckless optimism was not automatically enough. Prosecutors had to connect particular lies, particular victims, Holmes's intent, and particular electronic transfers beyond a reasonable doubt. Theranos therefore entered court as two related stories that could not legally be blended into one general verdict. The first important fact concerned what the company's machines could actually do. Theranos developed roughly 300 assays that used small blood samples, but only 12 were ever performed on its proprietary Edison device. Most patient testing relied instead on conventional commercial analyzers, sometimes modified to handle diluted finger prick samples. That distinction mattered because investors testified that they believed Theranos performed its tests on its own revolutionary platform. Using established laboratory machines was not itself fraudulent. Concealing their use while raising money for a supposedly working proprietary system could be. Former employees described repeated quality control failures and inaccurate Edison results, along with warnings delivered inside the company. Holmes's defense answered that laboratories are complicated. Individual failures do not condemn an entire enterprise, and she depended on trained specialists. That was a serious answer, because criminal fraud asks what the defendant knew, not whether every scientific decision was wise. The government therefore needed evidence tying Holmes personally to the difference between the public story and the internal reality. It found some of its strongest evidence in demonstrations prepared for important visitors. Witnesses described Theranos machines appearing to process a guest sample while secretly running what employees called a null protocol. The visitor's blood could then be tested elsewhere on commercial equipment. A null protocol is an admirably technical name for laboratory theater. Legally, however, the point was not the label. The point was that a demonstration could create the impression of successful proprietary testing without actually proving it. Prosecutors argued that Holmes knew these demonstrations were misleading and used them to build credibility with partners and investors. The defense maintained that demonstrations were not the same as clinical operations and did not prove Holmes intended to cheat anyone. Then came the validation reports. Theranos gave potential investors favorable reports, displaying the logos of Pfizer, GlaxoSmithKline, and Schering-Plough. Company representatives testified that they had not independently validated Theranos technology or authorized those logos. Holmes admitted placing the logos on the report. Prosecutors treated that act as unusually direct evidence because it linked the presentation itself to the chief executive. The defense could still argue that a logo suggested collaboration rather than authorship or endorsement. But An investor evaluating scientific validation could reasonably see the difference as decisive. The military story created another gap between possibility and achievement. Investors heard that Theranos technology had been used by the United States military in the field or on medical evacuation aircraft. Retired General James Mattis testified that the device was never fielded, installed on a medevac aircraft, or used to treat service members in combat. Holmes pointed to more cautious language in at least one recorded investor call, where military use was described as potential rather than accomplished. The jury had to examine the exact words attached to each charged investment. Financial claims supplied a fourth anchor. Theranos recorded no revenue in 2012 or 2013 and reported losses of about $57 million and $92 million. In 2015, it reported less than $2 million in total income to the Internal Revenue Service. Investors nevertheless received projections showing approximately $230 million in profit by the end of that year. One investor also recalled being told that military work would produce roughly $200 million in revenue. Projections are not promises, and startups are allowed to be wrong about the future. They become legally dangerous when unsupported forecasts are presented alongside false claims about current contracts, deployments, and capabilities. The defense argued that Theranos still possessed a valuable technology, employees, partnerships, patents, and a genuine plan for a new miniaturized platform. Holmes testified that she believed in the company and did not intend to defraud investors or patients. Her lawyers emphasized that scientists and laboratory directors held technical responsibilities she did not personally perform. They also presented evidence that Balwani controlled significant operations and that their intimate relationship included abuse and coercion. Holmes did not, however, claim that Balwani forced her to make the key investor statements at issue. The prosecution's answer was straightforward. Delegation may explain technical ignorance, but it does not excuse statements a chief executive knows are false. By the middle of the case, the legal question had narrowed considerably. Was Holmes an ambitious founder describing a technology she sincerely expected to mature? Or was she using claims about existing performance, validation, revenue, and deployment that she knew were materially untrue? Patient evidence made the moral stakes even greater, but its criminal path was more specific. One patient received a Theranos HIV result, indicating infection, before later testing returned negative result. Another received incorrect results connected to pregnancy. These were not amusing Silicon Valley exaggerations, and the trial did not treat them as such. A late 2015 inspection by the Centers for Medicare and Medicaid Services found laboratory deficiencies, presenting immediate jeopardy to patient health and safety. Theranos later voided every patient result produced on the Edison device. On appeal, Holmes argued that the inspection report and the mass voiding unfairly encouraged conviction based on regulatory violations rather than charged fraud. The appeals court disagreed. It held that the evidence was relevant to her knowledge and intent, while the trial judge repeatedly warned jurors that regulatory violations alone did not prove guilt. Still, relevance to intent is not the same as proof of every patient fraud count. For each charged patient transaction, prosecutors had to prove Holmes joined the particular deception, intended to obtain money, and cause the specified wire communication. A dangerous laboratory finding could support that theory without completing it. This is where public summaries often collapse the entire case into the sentence. The tests were bad, therefore Holmes committed every charged fraud. Criminal law does not permit that shortcut. In January 2022, the jury convicted Holmes of conspiracy to defraud Theranos investors. It also convicted her of 3 investor wire fraud counts tied to specific investment transfers. The jury acquitted her of the separate conspiracy to defraud patients, and 3 patient wire fraud count. A 4th patient count had already been dismissed during trial because the government did not present the expected witness. The jury could not agree on 3 additional investor fraud counts, and prosecutors later dismissed them. The jury gave no explanation for its mixed verdict. It would therefore be wrong to announce that jurors believed every investor witness, rejected every patient, or adopted one neat theory. The verdict establishes only that the 4 investor counts were proven beyond a reasonable doubt, and the acquitted patient counts were not. Acquittal did not establish that Theranos testing was accurate. It did not erase the patient experiences, the inspection findings, or the voided results. It meant the government failed to prove Holmes's criminal guilt on those particular patient charges under that demanding standard. Balwani later faced a separate jury and was convicted on all 12 counts in his trial, including patient-related charges. His verdict cannot be transferred to Holmes because separate defendants receive separate trials, evidence assessments, and legal judgments. At sentencing, the court found that Holmes's investor fraud involved at least 10 victims and produced a guideline loss of $120 million. The judge originally imposed 135 months in federal prison, followed by 3 years of supervised release. No fine was imposed at that sentencing. Holmes and Balwani were later ordered to pay restitution jointly and severally, totaling $452,047,268. Joint and several liability means the victims cannot collect that amount twice, but either defendant may remain responsible until the obligation is satisfied. The restitution order included investors as well as Walgreens and Safeway, which had entered major business relationships with Theranos. Restitution was not a $9 billion award, and $9 billion was not the proven criminal loss. That larger number described Theranos' peak private valuation, an important distinction that headlines occasionally misplace somewhere behind the decimal point. Holmes challenged the convictions, sentence, and restitution in the Federal Court of Appeals. She argued, among other things, that former employees had offered improper expert opinions, that regulatory evidence was unfairly prejudicial, and that cross-examination had been restricted. The appellate court agreed that limited portions of employee testimony drifted into expert territory. It nevertheless ruled that any error was harmless because the remaining evidence of investor fraud was overwhelming. The court also upheld the inspection evidence, the voiding evidence, the trial limits, and the restitution order. It concluded that the investors' Theranos shares had provided no meaningful recovery because they could not sell them, and the company ultimately collapsed. The convictions and restitution remained intact. Rehearing was denied, and a later amended opinion did not change the result. The prison term later changed for a narrower reason, unrelated to innocence. In March 2026, the trial judge applied a retroactive sentencing guideline amendment available to qualifying first-time offenders with no criminal history points. Holmes' sentence was reduced by 12 months, from 135 months to 123 months. The judge stressed that the adjustment did not diminish the enormity of the crimes. Holmes remains incarcerated, convicted of the same 4 investor offenses, and responsible under the same restitution order. The civil and regulatory consequences also follow different legal rules. In 2018, Holmes settled Securities and Exchange Commission allegations without admitting or denying them. She paid a $500,000 civil penalty, returned 18.9 million shares, relinquished voting control, and accepted a 10-year ban on serving as an officer or director of a public company. That settlement was not a criminal conviction and was not an admission. In January 2026, a federal health agency appeals board upheld Holmes' exclusion from Medicare, Medicaid, and all federal healthcare programs for 90 years. Holmes argued that an investor fraud conviction should not trigger a health program exclusion, especially after her acquittal on patient charges. The board rejected that argument because the statute required a connection to delivery of a healthcare item or service, not a conviction for defrauding patients. Her investor fraud concerned the capabilities and sale of blood testing services, creating the required connection. The 90-year exclusion did not reverse the acquittals or relabel them as convictions. It was an administrative consequence, applying a different statute to the convictions she actually received. That final distinction answers the paradox in the opening. Theranos involved one company, one technology, and overlapping evidence. But the law asks several separate questions. Did Holmes knowingly use material falsehoods to obtain these investors' money through these particular wires? On 4 counts, the jury said yes. Did prosecutors prove the charged patient schemes against Holmes beyond a reasonable doubt? On the counts decided by the jury, the answer was no. Did the evidence still show serious laboratory failures and support later healthcare sanctions? Courts and regulators concluded that it did. The case did not establish that every Theranos test was false, that every failed startup is fraudulent, or that optimism itself is a crime. It established a more precise boundary between predicting tomorrow and misrepresenting today. Theranos promised that one tiny drop could reveal the truth inside a patient. In court, the decisive test was whether Holmes had told the truth about what her company could already do. The legal boundary was not failure versus success. It was hope for tomorrow sold as fact to obtain money today.